So good morning, everyone. We're going to start. Today is September 28, 2017. We are in Hamilton Hearing Room A. My name is Christina De Leon, a member of the Landlord and Tenant Board. I will be hearing the matters in this hearing room today. We are on the record, and should you wish to purchase a copy of the recording, simply phone the Landlord and Tenant Board, and they will make a copy available to you at a modest fee. So in the interest of having a smooth, orderly proceeding with the least number of disruptions as possible, I would ask that you keep the noise level in the hearing room at a minimum. So, and that is to preserve the clarity of the recording as well. So please, if you'd like to enter into conversations and discussions, I would ask that you step outside and take your discussions outside. Also, please turn off your cell phones and your electronic devices, or put them on mute or vibrate so that they don't disrupt our proceedings. So throughout these proceedings, if you will, you may address me as Madam Chair, if you're comfortable with that. And as I call up your matter, please stand up and identify yourself and let me know if you are, as an agent of the landlord or the tenant, if you are a licensee of the Law Society of Upper Canada. It is a requirement that if you speak on behalf of a party before the board, that you are licensed by the Law Society of Upper Canada. Or maybe you fall under one of the exemptions. And some of these are that you are a friend of either the landlord or the tenant and you're appearing today and you will not be paid for your attendance today. Or maybe you're a family member or an employee of the landlord. Okay, just let me know. If you are here and your co-tenant is not here or your co-landlord is not here, please advise if you're authorized to bind your co-tenant or your co-landlord. That's very important as well. Okay. And if you're a tenant, let me know if you've seen duty counsel or if you are declining the opportunity to speak to duty counsel. So throughout the proceedings, we will try to observe order, and that means that in the manner of presentation of evidence, the applicant will have the first opportunity to speak. So as the applicant tells me his or her story, I will request that the respondent refrain from interrupting, disrupting, just be very quiet, take notes as thoughts arising from the evidence that you hear. And take notes, but don't interrupt, okay? Because rest assured, when the applicant is done telling me their story, I will turn to the respondent and allow the same full opportunity to speak. So everyone will have the same full opportunity to speak. And so I just want everyone to understand that we should not interrupt, we should not talk at the same time or talk above one another's voices, okay? So that brings me to the next rule. Please, I expect that everyone will extend courtesy and respect to the other party, to the board, to all the parties in the hearing room, to our tenant duty counsel, our dispute resolution officers, our security officers, all right? So please be respectful, conduct yourself as if you were in a hearing room. If we expect that you will be providing the truth in these proceedings, and that applies to your documents as well, that all these documents are true, genuine, accurate to the best of your knowledge, information, and belief. It is an offense under the Residential Tenancies Act to provide false or misleading information, and you can be subject to a penalty of as much as $25,000 as an individual. As a corporation, the penalty can be as much as $100,000. So please be very careful. I may ask you to make a solemn affirmation or to take an oath before you give your evidence. With respect to documents that you provide, please make sure that before your hearing starts, you provide a copy of these documents to the other party. And that will allow the other party an opportunity to review them before their hearing starts. So that way we avoid adjournments or delays. What else would there be? So at this point, I'm going to request our tenant duty counsel to please address the gallery. Thank you.
Hello, my name's Andrew. I'm a staff lawyer at Hamilton Community Legal Clinic, and I'm the tenant duty counsel that is scheduled for this block of hearings. If you're a tenant and you need advice on your case today, I'm here to give you that advice. I'm looking forward to seeing as many tenants as I possibly can. As soon as I'm done speaking here, I'm going to head to my office where I hang out. That's across from the registrar. The registrar is where you will file papers for this tribunal. Like I said, I look forward to seeing as many as I can, and for those I don't see, good luck. I'm in the middle of seeing the person from 99 East Avenue South. He's number 4 on the list.
Number 4. Okay. Thank you.
Thank you.
Thank you. Thank you. Just give me a second, please.
Good morning, folks. My name is Melinda Jamison. I work for the Landlord and Tenant Board. I'm a dispute resolution officer, as is my colleague, Pat Jackson. I thought I would talk to you really quickly about the ways people resolve their disputes at the board. There's the formal adjudication process. In the alternative, many people like to talk to each other, and that's what Pat and I can help you do through mediation, which is a private, voluntary process. It gives you an opportunity to have that conversation that's helpful to narrow the issues in dispute, as well as work out a private mediated agreement, or in the alternative, a consent order. I guess what I can tell you with sincerity is that it doesn't hurt to talk to each other. You take ownership of your own decision rather than have someone else make it on your behalf. There's lots of information that you can learn from dispute resolution officers about the policies and the guidelines at the Landlord and Tenant Board. And finally, in the event that you're not successful, you're certainly welcome to come back before the board member, who will hear your case and issue an order accordingly.
Yeah, 99 East Avenue, Unit 2.
Yes.
SOL 84-218-17. So please state your names for the record.
Yakme, Y-A-K-H-N-I, initial V, paralegal, representative for the landlord.
Landlord John Serino.
Maribel.
Paul Peter Bosch. I normally go by my middle name, Madam Chair, so if you hear someone refer to Paul or Peter, they're both me.
And did you see duty counsel?
Yes, ma'am.
Yes, you did. I have some connection to this. Are we in the midst of this? We've heard evidence.
Yes, Madam Chair, and it was adjourned. I believe Mr. Bosch wanted to enter some video. He needed time to provide that to the other side. And
Was that provided?
yes, it was.
Okay. So can you bring me up to speed on where we are today?
Okay, well, we have a couple of motions. I think we're supposed to bring those up at the meeting.
All right, yes.
The first is a motion for dismissal of the application based on the fact that the original N5 is defective. That would be the one dated May 24th.
Okay, May 24th.
Okay, there aren't enough details here for us to properly respond to this. There are no times or dates attached to particular events. For example, the first one says February 24th, 25th, videotaping and taking pictures of the tenant's unit against their wish, smoking marijuana in the building which is making tenants ill, and the tenant's letter attached. Well, the tenant's letter essentially says that he claims there's a constant odor of marijuana in the hallway and that we're looking out our windows. I'm not sure that either one of those is a behavior that we can correct. And the second one here is They've been trying to put me in the middle of their problems with the landlord taking pictures of the building, and they're constantly bothering me with letters for the landlord as they don't want them at their apartment. Well, Mr. Pollington is Mr. Sereno's agent, so I'm not sure exactly what behavior they're asking us to correct in the first instance or the second, interfering with the landlord's agent, Richard Pollington's ability to fulfill his duties.
And then police report attached.
Yeah, but the police report essentially says that Mr. Pollington feels harassed and doesn't want to be put in the middle. And I agree, he shouldn't be, but he is Mr. Sereno's agent, so he was in fact our only timely means of communication with Mr. Sereno.
So you do understand,
Yeah,
you
but
do
how-
understand that, what that statement refers
But
to?
how are we harassing somebody for them doing their job?
Yeah, it's,
Well, that's the defense, right? But as to adequacy of the notice, the fact that you're able to respond to it now by saying, you know, he's the agent and that's why we deal with him, that tells me you understood what
Okay.
the allegation was, right?
okay. And for May 10th, we're not sure exactly what he's saying there either.
That date it was in between two tribunal hearings, right smack dab in the middle.
And he
The
wasn't there.
9th was a tribunal date, the 11th, and he wasn't there the 10th.
Yes. So that's a defense.
Okay.
I'm hearing that it's a defense
But-
rather than, so you're saying the date is incorrect, but you're not saying,
The date on the other ones are wrong too. There's too many
Yes.
facts
Yeah.
that are wrong.
Madam Chair, if I could, I don't need to
yes.
interrupt, and I
Well,
do
what are your
apologize.
submissions then?
But I just wanted to point it out that the landlord and Mr. Pollington also testified. We heard testimony on these events. The first and five was voided. Those behavior was corrected. Both sides testified to the fact that it did happen. So there was a valid reason for the first and five. And the landlord did confirm that those behavior was corrected within a 7-day period, thus void that first and five. But subsequently after, in early June, there was additional reason for the second and five.
The second and 5 dates, everything are wrong
All right.
too.
Okay,
And I
but-
mean everything.
All right. And those are defenses on the merits,
Okay.
right? And the fact that you can mount a defense to the merits suggests or indicates to me that you know what these allegations are, and or that you know what the accusations are, and you're able to say, no, we weren't even there on that date, or he wasn't even there on that date. Those are matters for defense. Okay, so that motion, and as pointed out, on the evidence that we had at the first hearing, you did void it. In other words, you
Okay.
ceased whatever they accused you of.
All right. And that's-
Okay.
What is the second motion then?
Second motion, we only got disclosure from Ms. Yachny on Friday, the 22nd of this month. We would like some time to prepare a defense to some additional allegations that she's made.
And to get a police
We
report.
need 30 days to get a police report.
Mr. Bosch, what disclosure, I think those, we have the tenant's application, and I believe those disclosure were pertaining
There
to
was a
The letter
witness
from
statement.
Mr.
Mr.
Pollington's
Pollington.
daughter-in-law concerning the Labor Day incident where the police were called. We would like to get a copy of that police report, and you did not give us enough time to do
Well,
that.
Madam Chair, this letter was provided to my office, and that the very day that I received this letter, I provided to Mr. Bosch.
And do they don't form part of the events that are set out in second and five, do they?
No, it doesn't matter, Chair. This is just additional incident after the
That
application.
may go into section 83 analysis, whether I should delay or deny eviction. So, but do you have all the disclosure with regard to the events set out in the second and
There was no
five?
further
They didn't give us
disclosure.
any, so
And what did I order for the
The
disclosure?
30th of August.
If any, right?
Yeah.
That's
A copy
correct,
of all
Madam Chair.
evidence in reply, if any, to the tenant's evidence.
And we did not have need for a reply evidence to the disclosure that Mr. Bosch provided. There was a few video clips. The dates of those video were not in the material time that this application was based on. So we intend to object to him entering those into evidence. I believe at that hearing we had requested that those video that he's going to be submitting be pertaining to the time.
Alleged events in the N5 notices.
Madam Chair, it's impossible for you to understand the context of those videos without seeing what happened before. It's
Not to mention, they brought up May 10th. May 15th is the day they came in.
Well, that's right. That's your
And that's on
defense,
video.
right? That's right. That's right.
So trying to get those videos dismissed is kind of funny. And there were
So I
incidents.
will allow that because the defense is that you've alleged an event on May 15th.
No, the 10th.
Or the 10th. No, I'm reading from here that on or about May 15th. you
From the
made
second N5,
The
yes.
second N5.
Okay,
yeah.
second.
Yeah.
But there was no entry on it, okay, that's part of the
Yeah.
defense.
But yeah, so those are your properly
Okay.
brought up as matters of defense. So yeah, I believe then the video evidence would be irrelevant insofar as you're going to say your dates are wrong, and it could go to credibility. It could go to those events could not have happened because here is a video of what happened on this
Madam
day.
Chair, I would be in agreement to allow those pertaining to the May dates, but I believe correctly that those video that was submitted was dated the February period of 2017. So those I'm objecting to because that's beyond even the first N5 we've served.
Yeah, well, how would that be relevant?
Ma'am, it shows why we felt it necessary to have cameras in our unit. And Mr. Sereno's whole objection has been that simply lensing him has been harassing. He's repeated that theme. He's been antagonistically aggressive and a physical bully, and we had hoped to record that, and we did. Mr. Sereno's, as I said, it's impossible to understand the
Okay,
events.
so it's context.
Yes,
In
it
the
is.
same way you're attempting to introduce the Labor Day incident as context, context of the entire relationship, so that I can appreciate the relationship and why these events occurred.
Yes, ma'am.
What are your submissions?
Madam Chair, I would state that we oppose it, but it's Madam Chair decision. But I want to point it out, this is before even the time period for the first N5.
Yes, I understand.
And the letter that we intend to introduce is to show that the allegation in the second N5 did not stop because this application was brought to the board. It continued. And that's the purpose of it. But we are open to matter.
Yes. So I think the purpose for the February and the Labor Day evidence both go to the same point of this is the context. We have a mutually a relationship that's problematic, and so I think to appreciate the context so that I can make appropriate findings. Okay. So let's get on with it. So what? Somebody please refresh my memory. Where did we leave
We're
off?
not done yet.
Oh, you have further motion?
We have a motion to adjourn until after our T2 application is
I
heard.
see.
This part of, this is, in our opinion, part of Mr. Sereno's harassment. He's, all of these allegations were made since we brought our T2 and our T6 application against Mr. Sereno. Until then, there were no great difficulties in our relationship. The,
5 months into our case, they
Yeah.
brought this in.
And when is the hearing of your T2 and
We just had one Monday.
We just had one Monday, which has, again, affected our ability to prepare this case. Ms.
And
Ball suffered a migraine attack, and she's only just recovered, and I'm starting.
Madam Chair, if I may add it, the tenant application was filed in December 2016 and has had more than one adjournment for different reasons, some of which was Ms. Ball's medical condition that we consent to
One.
the adjournment.
One for my migraine.
However, the landlord application was brought in good faith, and the N5 were given in good faith, in the fact that it's not malicious, and it's not because the tenant has brought an application before the board, but because of valid reason. And we heard testimony from the landlord and his witness to those. We heard testimony from the affected tenant that was subject to some of the tenant's behavior.
so was the hearing completed and we're just awaiting the order?
No.
No, Madam Chair, it's expected to go on for quite a bit of time because Member Henry indicated that this would be a case that would need special circumstances. It might be more than one part of it heard, depending on Ms. Ball's condition of the hearing. So we might be looking at a few months going into 2018.
Oh dear.
But Madam Chairman, there's no urgency for the landlord. The rent's paid up. There's no reason for him to come back to the apartment for repairs. Those have been completed. So at this point, there's no reason for, it's not going to be any hardship to the landlord to adjourn.
The alleged hardship is the alleged harassment that he experiences.
How does he experience it if he has nothing to do with this?
Yeah.
And Madam Chair, the T2 and T6 is for rent rebate and repair. All the repair has been completed.
What,
No,
what,
it's
what is the
not.
T2
No,
about?
it has
Well,
not.
there you go.
The
Okay.
T2
The
is
repairs
harassment.
are not, the T2 is
He won't do
harassment,
Yeah, there's a couple of
He won't
minor
do them.
issues left on the repairs, Madam Chair.
but T2 is harassment? Or
Yes, the T2 is harassment, coercion, and illegal entry.
do they overlap in any way?
Yes.
With this application, they're the same, it's the same.
This
ma'am.
is part
This
of the
is part of
harassment.
our harassment
We've already
application.
included this in our harassment, the
Yeah.
2 T5, or the 2 N5s.
Yeah.
Before they filed this, were included in our harassment case.
The
Madam
first,
Chair, it's not included in the
First
harassment.
Or sorry, the first N5.
yeah, we're only up to June
Wait,
30th
at,
on our
at
harassment.
the last hearing, Mr. Bosch handed me a folder. In it was copy of the N5s that we provided, but it was never introduced into evidence in the tenant's application.
Which
Member
amendment?
Henry already heard the T6 application, the tenant evidence, and we were about to commence direct examination of the landlord at the next scheduled hearing.
Well, Madam Chair, we haven't gotten to our T6 yet, so, or sorry, our
So have
T2,
you or
sorry.
haven't
We haven't
you?
gotten to our T2 yet. He's just tackling the T6 first.
Yeah,
So we haven't even had a chance to present the T2. So,
Are you looking to stay in this unit?
yes.
Yes, ma'am, we are.
We can't have you looked at the cost of rents?
But he's trying to evict us simply because we brought an application for repairs. That's where it escalated from. Now, we don't mind him having his day in court, but we just want some peace from the man long enough to have our day in court. That's all.
I think he wants the same, like, because this
No,
is...
he wants us out.
No, because this is, the nature of this N5 is interference with his lawful rights as a landlord.
Okay.
So you want the same thing, which is peace.
And Madam Chair, our L2 application was only filed July
July.
25th, and the tenant application was filed in December. So it wouldn't be reasonable to say that the landlord is only bringing this application. If that was the reason, he would have done it shortly after the application, the tenant application was
Well,
filed.
no. Mr. Sereno had missed a deadline
Okay,
for,
all right.
for repairs, and
He didn't do this until bylaw got on his
Yeah.
backside.
Property standards told him fix it or we'll send the contract.
And that was in January 2017.
No, that
That's
is not
the
when the
problem.
contractors were threatened. The contractors were threatened in May.
Ms. Ball, what I was saying, that it was on January 6, 2017, that a property standard order was issued.
Okay. Now, just
And-
give me an idea of the issues in your T2 and T6, just very briefly. please.
T6, we
T6.
needed all the interior doors in our apartment replaced. We needed the exterior doors in our apartment
Okay.
fixed.
All right.
We needed flooring in our apartment fixed.
All right.
We needed a toilet fixed. We needed, what else? Windows fixed.
Madam Chair,
Okay,
if
what
I may
about-
object, there was no toilet issue.
Okay.
It's
T2.
on, it is
Okay,
on
that's
the order.
that's good enough.
Okay.
T2. What are the T2 issues? And I'm just going to see if they overlap in any way.
Okay, there are multiple.
Oh, just give me a brief summary.
The landlord
please.
thinking, for one, back in December, he could walk into our unit without
Illegal
giving
entry.
24
Yeah.
hours
Okay,
notice.
what else?
We have, I have the order here, or the application here. Okay, illegal entry on January 14th, 23rd, 24th, 25th, and 31st.
Sure. Okay.
this year.
Illegal entry. Yes. Next.
May 16th, 17th, 15th, any number of them.
Yeah, I don't need the dates too much. So January to May. What else?
And
What are the
appeared with
allegations?
reasonable enjoyment.
Yeah, this is all from December of 2016.
Yes.
So,
Is that a spare copy I can look at? No.
Yes, ma'am.
Okay.
Madam Chair, if I may just add, all those entries were as a result of a 24-hour, at least 24-hour
That's your
notice given.
defense. Yes, they're saying it's illegal. So, just
And
want to
the
see.
landlord was asked to accommodate the fact that I am bipolar, have PTSD, and his abrasive manner.
Okay, I see here as well. There's allegations of June 26, 27, and 28,
Yes, ma'am.
which are the same interferences that the landlord has alleged.
Yes, ma'am.
And that's an amendment that was filed for the T2 after our application and the hearing, our last hearing.
It was filed July 21st.
And yours was filed July 25th.
This was filed with the,
Would it be
no.
fair to say that issues are intertwined?
Yes.
Yes, Madam Chair.
I want to ask, yeah, that's your point, Miss.
I would agree with Madam Chair that with the incident in June, 26, 27, 28,
Mm-hmm.
they are.
Mm-hmm.
However, Madam Chair pointed out that the tenant amended July 21st. We would have filed and served the second N5 on the tenant, so the tenant had knowledge that we had the option of proceeding with an application, or we could have done that.
Yeah. And there's also May 15, which is alleged in your N5.
Yes, Madam Chair.
I would almost say it's worthwhile to hear them together, except I'm ceased of this, and Mr. Henry is ceased on the other one.
And if you recall, the last time we were before you, we tried to put that forward, but you said we should have done that, and we did not know we should have done that ahead of time, and it was too late.
Yeah, we had very
That's-
little time to prepare for this. And Mr. Serino had been harassing us in person up until August the 2nd, and the hearing was August the 10th. And this-
So that's
Are
why.
there any measures we can put in place in the interim that you can suggest?
We've asked that Mr. Serino not have anything to do with us.
But he's the agent.
Madam Chair, and
But there are
that
other-
is the underlying issue, that Ms. Ball and Mr. Bosch wanted to prevent the landlord from accessing his property.
No.
No,
We feel
our
that's malicious.
unit,
Okay,
our unit.
so we all want peace, right?
Yes.
What interim measures can be placed in an order so that pending resolution of these
We
applications?
deal with his brother. That's
Yeah.
all we're asking.
He has a
His-
co-landlord, Augustino.
Who,
Yeah.
and what is the
Agostino Serino.
involvement of Agostino?
He's co-owner.
He,
Madam Chair, he's
Yes.
he's not entitled. Mr. John Serino is the sole owner of the property. His brother does do a lot of repair. They work together. However, ultimate decision is Mr. John Serino. He's
Can it be that Mr. John Serino authorize or be the approving individual, but the person that enters the unit and deals with the tenants would be Mr. Agostino Serino. Would that be a possibility pending the return of this?
Madam Chair,
application?
that would be, you want to discuss? Sure, go ahead.
There's many orders in the work orders that were provided by property standards,
Yes.
which they refused me entry into their unit.
Mhm.
They're using their own little game of holding us back from doing our work.
Yes. I'm wondering if your
Me and my-
brother.
Me and my brother
Mhm.
have jobs to do.
Mhm.
In one instance, we had to measure the windows so I can order windows. There's many windows to measure. I have to get into each part of the apartment. They were stopping me from entering, saying, we're not letting you in. We want to know where you're working. I said, my answer was, I'm here to do the orders
Yes, I remember
and
this
property
evidence.
standards.
I wonder if Agostino can do that.
He can't
On
do
your
all the work.
behalf.
If I'm on a ladder, and my brother, I'm measuring the window, I want him holding the ladder.
Okay.
But there's no more work to be
Not only that, we
What
have
is the work that remains to be done?
carpets.
Perfect.
And
Carpets.
that is required by me.
Okay.
May I,
Is it possible that he enters to do the carpets
I-
and you won't be there?
can I say something to,
Is it gonna advance?
I don't,
or
it may or may not.
detract?
We have paperwork that states the two of them as owners of this property, Augustino as owner.
That's right.
And
That's
just John. So if we have different paperwork stating.
No. It's just a matter of they're both. He is necessary for flooring. He's necessary for measuring
Okay.
windows.
But there are other people under his purview that can do the work.
And Madam
It's
Chair,
not
we did
just
suggest
John.
that to Ms. Ball that if they find the landlord present to be offensive, that they not be there while the work
I
is being
have to
complete.
leave my home because he can't behave.
Okay. So is it just the flooring that remains to be done?
Yes, and we'll forego that until after the T2 hearing. okay?
Yes,
No
we've
problem.
gone this far.
We've gone this far, we'll put up with the carpets this long.
He has stalled me more than once on putting the floor in.
What is the prejudice to forestalling the work?
We came in, my brother's my witness. I always approach with my brother because
Yes.
I don't want.
No, but what would be the prejudice to forestall the completion of the carpeting?
The first time we went in, we had a tribunal date 3 or 4 days after.
Madam Chair.
No, Miss Yaki, what is,
Madam-
they are okay, so you're not going to be able to say at the hearing before Mr. Henry, the floor's not done, or because
That's fine.
you are
That's fine.
saying to me
That's
on the
fine.
record,
That's fine.
we're fine for
That's
the
what it
carpet
is.
to not be.
If that's what it
Yeah.
takes for.
May I
Madam Chair.
state that they've continuously said that the carpet smells, there's an odor in the room, that he hasn't done the work. We have done our due diligence to try and go in, and they have stalled us every opportunity that we tried to go in.
Madam
Okay.
Chair, I believe we're going to have, it's going to create a hardship for the landlord because he has to visit the premises for other tenant, he has to do work, it's his
Okay.
property for various reasons.
Okay.
So there's going to be an issue with dealing with the tenant.
Yeah.
Now, if I may, Mr. Sereno, the fact is, the tenant application has been adjourned numerous times, and we believe the tenant is using that as a delaying tactics, and we're going to have other adjournment. Member Henry indicated that he don't see this being completed in one hearing. It might be in different part of it we hear, more than one to accommodate Ms. Hall.
I'm going to see if we can be creative about doing this. I don't know if there's a possibility to co-panel because I do believe the two matters should be heard together because they overlap.
Yeah.
Yes.
I will just explore that.
May I also
Okay.
state
Yes.
that in the first of every month, they require me to come and collect the rent. My agent is Mr. Paulington, over here. He has collected the rent successfully for their first year without incident or problem.
Yes.
All of a sudden, they created an issue against Mr. Paulington, which I believe has been done purposely to force me to come to the door.
Okay. All
So,
right.
so here they are, they don't want me to come.
All right.
Can I answer that?
May I just encourage? May I just ask you? Our mediator is here. Okay.
We've already
No,
tried
no.
mediation.
I'm not going to ask you to attempt mediation to resolve all the issues. interim measures that we can put in place in the meanwhile, so that the interactions can be as frictionless as possible. For example, only Mr. Agostino will collect rent. I don't know. I'm just throwing that out there.
Perfect.
Or,
We've asked for that.
or, you know, I don't know what you can work out, Mr. Serino, Ms.
Yes, ma'am.
Yati. Would you be willing to attempt that?
Madam Chair,
Just-
we are willing, the last hearing with the tenant application, the mediator indicated that they don't see this being.
Okay,
a
I'm
No,
going to ask,
that's not
please,
how it
if you
went.
want to adjourn this matter, would you be willing to just attempt to enter into terms on a temporary measures to take you to the next hearing date, so that in the meanwhile, everybody can have peace? Just temporary measures that
Madam
we
Ch-
can put in place.
Madam Chair, one of the terms we would ask in that event is that whenever the landlord has to do repair, because of the
Which-
interaction, that the tenant
Mhm.
not be present. to-
Well, could you try to thresh that out with Ms. Jackson and see if you can enter into those terms?
I
Okay.
would be willing to have a
Would you
discussion.
please attempt that?
I have a dog. They have no respect for us.
Okay,
I'm worried about my animal.
okay. Try to, could you, if you can't come into an agreement as to the interim terms, then I'll hear submissions on what those terms should be, and I'll make a decision.
Okay.
Okay, I'm just gonna try to see.
We can have separate rooms.
They want to deal with them separately, so caucus here and caucus there.
Thank you, Madam Chair.
Yes, yes.
Yeah, SOL 84218.
Yes, 814. Okay, so this is 99 East Avenue, Unit 2. So we have a partial agreement on terms for
Yeah,
interim order?
the parties agree that the tenant can pay their rent moving forward until the next hearing to the landlord's agent
That's correct.
at 2557 Barton Street East, Unit
20 Okay, got it.
Unit 1.
Unit 1. Yes.
And the parties are agreeing that the landlord will not enter the unit to replace the carpets. The tenants are stating that they are not requesting an abatement of rent on their tenant applications with regard to the carpet.
With regard to delaying
Carpets, yeah.
With regard to the carpets?
Carpets, S. However, that's an issue that they will deal with the tenant's application next hearing.
So is the waiver of the rent abatement only for the period from today till
I think
that
they had
issue?
requested a specific abatement for the carpets.
Just a general.
General, we will not request abatement for the carpets.
But they still want to have them replaced
Mm.
and to be dealt with at the next hearing.
It's dealt with at next hearing. Okay,
Yeah.
then?
And then basically the landlord is still wants to reserve the right to enter the unit to do any future maintenance and repairs. So that issue was not agreed upon, and the tenants say they will still videotape or tape the landlord in the unit or on the property, and that issue was not resolved.
That's correct.
Well, what repairs are outstanding? I
It's
thought it was
more
just
of-
the carpet.
Yes, that's correct, Madam Chair. I apologize for interrupting. But it's more of any maintenance that would arise or any property standard that he would need to go in. He's agreed that he would provide the tenant with at least 24-hour notice. He's also indicated that he would be more detailed in those notice. I would be involved in the preparation going forward of those notices so that the tenant would have sufficient information as to when and what they're going to do. And, you know, or if it's not a specific time, a period of time that they expect to be in the unit for the work to be complete.
And that's really a right of a landlord. You
Okay.
can't interfere with that lawful right to
Can
maintain
I-
the property.
Okay, but
Right?
can I add something?
Yes.
When it's stuff like bleeding of the rads, I am quite capable of doing that. I was responsible for 5 buildings, 60 units as a superintendent and had to do that myself. He doesn't need to come in for that. I'm capable.
She doesn't know that John
I'm-
indicated he wanted to come in and bleed the reds. That was one of the things that...
I'm just going to make a suggestion about specifying the time. Could we say it would only be like a 2-hour window? Be more specific about the
You
time.
don't
I know
even
there's
need
been
2
some.
hours to bleed rads. It
No,
should
I'm
take
just
less
saying.
A window.
One of the issues was that they
Yeah.
give 6 hours.
But if it's something, I'm requesting, if it's something I can do, can we at least,
And the
Something as
landlord
simple
is
as
not
bleeding
going
the
to agree to
rads.
the tenant doing any repair because the proper, you know, standard has been involved and they
Yeah.
want the landlord to be responsible for all
That's
repairment.
that's their right and responsibility,
Okay.
and if they're not prepared to delegate that to you,
he had no problem last year.
great, but we're in litigation.
All right.
How about if his brother does it? Augustino is qualified to do it.
And
And we've been there and they're not agreeing to that.
That's correct, that's
Yeah.
correct. Madam Leader was there present and he's indicated he do not want to be involved in that situation. He felt it very, you know, uncomfortable. and-
Uncomfortable. Okay, that's their lawful right. I mean, that's in the RTA
All right.
that they, you know, have the right to enter to do repairs, provided they serve 24-hour written notice pursuant to the Act. And the compromise is that they're going to be very detailed. Ms. Yatney will be involved with regard to specifically what repairs they're going to make, and when and what, and
And what room
two-hour
they're going to
window.
need access to.
Yes, I would be as.
What room they're going to need access to,
Yes,
like
please.
not
That would have solved most of this from the beginning.
what room to access, and a 2-hour window, provide a 2-hour window.
I'm expecting that would be reasonable. I don't foresee any major work needed to be done that has been completed, so it would be regular
Yes.
maintenance.
Yeah, so that you don't need to, you know, allocate an entire afternoon. You just 4 to 6.
And if you want to leave the unit, you can.
Mhm.
That's an option.
And what about the videotaping?
With his behavior,
Ma'am.
we're not giving that
Yeah,
up.
we're just not safe without those cameras running.
And
It's
Madam-
about the only thing left that restrains his behavior.
Madam Chair, the landlord is requesting, with regards to the videotape, he understands the tenant reserved the right to videotape in their unit, but he's asking that the video recording outside of the unit, around the premises, and invading other tenant space, because they have filed complaint with the landlord, and as you're aware, those tenants could bring an application before the board if he ignored their complaint, so he's asking that be stopped.
Outside of our unit?
Yes, other tenants, their own privacy.
What other
Okay.
tenants?
Are you the sole tenants in this?
No, but this is the first we've heard of other tenants.
Well, the
No, he's talking
superintendent-
about Richard.
Yeah, that's
Oh,
correct.
the party he was
Yeah,
having,
yeah.
disturbing us.
Okay, if,
Yeah.
we
that
won't
seems-
video outside of our unit, but if there is something unlawful going on, we're going to point a camera at it.
Unlawful.
Creating a disturbance, uttering threats, any one of the things that have happened so far.
The incident they're referring to, there was a party going on, the music was blaring so loud from the unit below us, inside their unit.
So we went out with a camera to record the noise level.
I think
And
Mr.
there
Bosch
were-
is referring to that new evidence that we talked about this Labor Day weekend.
Mhm,
The other tenant was having a barbecue with family over. I
It
believe the
doesn't
police
matter
was
that it
called.
disturbed us.
Okay.
I don't think you need any more.
Thank
Okay,
you,
you're
Ms.
welcome.
Jackson.
The music was loud, we could hear it in our unit with our windows closed. But that's okay, right? That's what they're saying.
See, the thing is, they keep coming up with multiple witness statements that are not factual. Okay, they contradict the videos. Without those videos
We've
or
got nothing to
recordings,
prove
we
it.
have nothing to prove it. Now, we're not intrusive with the camera.
So it's not going to be on 24 hours?
No,
Is
it's
that-
never been on
it's never been
24
on.
hours.
No, just when things start to get wacky, that's when we turn the cameras
The
on.
incident that the landlord is referring to in particular, there've been times when he's doing repairs around the property that Mr. Bosch would approach him, would videotape. He was specifically asking, can you please not do that, it's distracting, I find it harassing. And he would refuse, and as a result, they would be back and forth, and the situation would get uncomfortable. Also, he's received complaint from Mr. Pollington, who is a tenant, also he's a superintendent, that the tenant would go and videotape him. You find that an invasion of his privacy. Once he had his grandchildren over, and he was very upset about that they were being videotaped. So that's what we're asking, that conduct stop.
Yeah.
At least within the interim until.
Yeah,
this
within the
matter-
interim when he's doing work in the exterior,
That's correct.
because he's distracted by that. And that Mr. Pollington,
Yes.
the other tenant, if he's carrying on his usual day-to-day activities, right? What was he doing when he complained?
So they were having a barbecue with his family member, Mr. Bosch, approaches, start videotaping, and he had his grandchildren around, and Mr. Bosch was videotaping. They find that very upsetting. He told him to stop. Mr. Bosch refused to. He said, I need this for the tribunal hearing. Mr. Bosch have a right to gather evidence for his hearing, but he does not have to invade other tenants' right. And because that tenant has already filed a complaint to the landlord cannot ignore that complaint. So that's what we're asking within the interim until this matter is resolved for the hearing, that the tenant stop that conduct of recording the other tenant or the landlord while he's doing repair outside of their unit.
Well, if he's doing repairs outside, no problem. I have no interest in videoing that.
Yes.
But again, if there are a disturbance or
Loud
something
partying.
going on that's affecting us, coming from Mr. Pollington or Mr. Sereno, I
Like
don't.
a barbecue with grandchildren?
It was loud. There was a
There
lot
was
of
the
music. It was
music.
very loud. And I did ask him to turn it down, and I was told, go ahead and complain. You're getting evicted. At what point does it get to where?
Madam Chair, I believe Mr. Pollington, family member, had to call the police. They were called, and police were involved. We would get a copy of that report. So for the next hearing,
And the police looked at the video when there were no
Yeah.
kids on
I
the
showed
video.
them what was on
Nice
the camera,
try.
and they said, okay, don't worry about it. Okay, the individual who called the police, a part of the video is her telling the dispatcher on the phone that he was shoving the camera in my daughter's face. And it's simply not true. Okay, there's a lot of exaggeration.
Well, you see, it seems to me that that would go to the merits. We're already getting into the merits, and was that substantial interference or not?
Okay. Now, I don't mind, okay, not videotaping outside is fine, but if they're doing something that is relevant to our applications, or maybe the subject of
disturbing.
another application, I don't see why we can't lens that. If they're out in public, visible to the public, that shouldn't be a problem. There's no expectation of
But
privacy.
how do you do it? Are you in like?
No, I stand back away, okay? We're not in anybody's face with this. Ever. The
'Cause I
videos
can
will show that.
understand how that's disturbing to children, right?
We can be further away than you are.
I didn't even
You
know
and
there
I
were kids
are.
there when I came down. Okay, it was a loud party. They have loud drunken parties every other weekend. I didn't know there
Or
were
as
children there.
often as they want. They do it through the winter in his unit.
Well, so you're prepared not to videotape the landlord when he's doing repairs outside?
We don't, I don't,
I can't tie their hands in regard to, there's a disturbance. There's a disturbance. And in a way that if it's not a true disturbance and they're alleging it as a disturbance, then that's evidence useful to both.
And I agree, Madam Chair. If that conduct is an interference on the other tenant's right, and that's part of our L2 application, so that the tenants know that, and know that the reason the landlord is requesting this is that were he to ignore that other tenant complaint, he could be faced with an application before the board.
And that's,
Okay, we're just trying to do interim terms.
May I?
So-
This is a tenant that is also an agent of the landlord.
All right. So I think the most I can do is to say that the tenant not to videotape repairs by landlord outside and normal, but that's where we're going to get into
well, if we have the video, you'll be able to decide, man.
normal day-to-day activities, because that's in dispute, eh?
That's
What's normal? What goes outside?
You'll be able to decide.
Normal day-to-day living, normal day-to-day activities of other tenants, okay?
That's fine, we don't do that.
So if,
I think that would be acceptable.
okay.
Thank you for that.
Thank you. Okay, so the terms of our interim order pending return of this matter, and hopefully I can get a full panel. Tenant to pay lawful rent to the landlord's agent, Ms. Yatni, at 2557 Barton Street East, Unit 1. Whether or not she's there, you're going to be able to leave the check.
Yes, and I would
Cash.
appreciate Mr. Bosch giving me a call if that's you're able to, just confirm that I'm there, or an email.
Well,
Receipts
we
will
pay
be there.
cash.
Absolutely, I will provide you with a receipt.
Okay, so we'll set up a meeting on the first then.
I appreciate that.
Okay.
Landlord will not enter unit to replace carpets, and tenant will not request abatement of rent in regard to the carpets in your tenant applications. However, the issue of replacement of carpets to be dealt with at the next hearing. Not on consent, or on consent maybe, landlord reserves to enter right to do repairs with 24-hour notice, which will be detailed as to when, what room to access, and will provide it to our window. Will that be on consent? Yes. And lastly, tenant will not videotape the landlord when he's doing repairs outside the rental unit, and will not videotape normal day-to-day activities of other tenants. The normal day-to-day.
Mm-hmm.
When it, okay? All right.
Thank you, Madam Chair.
Thank you too.